They ready? I don't know if they're ready. Let me tell the boys.
Lou here.
Hey, Dan.
Yes.
So Lou, why don't I just give you this and then I'll explain what this is to the board? Yes. They want it.
11:21, all members present. Work session. You're on.
All right.
Live.
What I just gave Lou will be a contractual matter, and that will be executive session. Before I begin, look, does
You're on.
anybody have anything before?
I do, actually, if you want. If you want me to start, I can start.
Please do it, yeah.
I see, Mr. Supervisor, you put on here, the town board to authorize the town clerk to advertise for a public hearing on January 23rd to modify application for special exception heard on September 20th.
Right.
From everything I've read through the planning department and everywhere else, I don't
Yeah, no,
see the
I
need
know,
for a
I-
public hearing. The public hearing was heard, and to start putting a new public hearing is all new evidence, and it kind of starts the process all over again. The public needs to know what's going on, and I think if we just do an informational hearing, so people can come and say what they have to say, and we can hear how the project's gotten better, I think that would be better than open it up to / a legal public hearing. Let's just have an informational hearing, and that way the applicants don't have to bring attorneys, witnesses, and everything else and go to that expense. I think an informational hearing to the public would be a much better way to do it.
All right. Well, I think that's something he may have to ask, but I mean, I was very straightforward in my memo. There's a lot of changes, and I think we discussed that once before
Right.
here, and I think, Kevin, you agreed on a public hearing, I think, and Bobby might have said that, let's have a public hearing.
No, I don't think we should.
But, okay, but my feeling is that there's so many changes to this application, and I put it in my memo. Do you have it there?
I don't remember, I just have the agenda
You know, it's
item.
height differences, a new sewage plan, which is better than what the people heard, buffer zones being extended. I think the people who came out should know that those things were happening.
Yeah, I think that could be done by an informational hearing, not put,
Well, ask him whether it should be public information.
I think informational hearing to the public and let them know where it's gotten
Well,
better.
listen, I made that suggestion. You could take it off if you don't want to do it.
No, I think the people should be heard, and the applicant should be heard to tell us how much better it's gotten done. But not, a public hearing has a whole different
There's
weight
no,
than an informational hearing.
No, you wrote there's no requirement.
there's a couple of things. There's no distinction between a public hearing and an informational hearing.
Oh,
It's
okay.
a public hearing. A Couple of things I have,
No, they have different weights.
no,
According to the Association of Town, which I called,
Yeah.
they make, there is a difference.
the town board has the absolute right, if they want to put it on for another hearing, to do it. The law does not require it. I have my office, I didn't know this was going to be spoken about this morning, so I apologize. I have my office bringing down the file, but one of the reasons why my opinion to the board was no public hearing is required as a matter of law is all the changes that were made are less intense. They reduced the height, they reduced the buffers, they reduced the retaining wall heights. And Dave Flynn did a memo on October 8 outlining the specific changes, and all of the changes are less intense. Also, it's my understanding that the application was heard before the board, the town board, and the application by the Board of Zoning Appeals. The applications that were presented and filed were the same, so the public had an opportunity to be heard at both hearings. What I believe the applicant did was, as a result of comments and issues that were raised before the Board of Zoning Appeals, said we're going to reduce our requests. So it's not a case of going from a less intense to more intense, it's the exact opposite. And I had seen your memo, Supervisor, and I was just concerned because I want to make sure that I give, obviously I want to provide the best advice to the board that I can, and I had the staff in my office yesterday research this stuff just to make sure that I didn't miss anything.
Right.
And we all came up to the same conclusion. No additional public hearing is required.
No, and I understand that. I said that in my memo. My point is that what will ultimately happen is substantially different than what the public heard on September 20th, 2012. That's a long time ago. And I would think that the fact that those, what the purpose of a public hearing is to elicit comments from the public regarding an application. Is that correct? It's purpose of
That's
public.
absolutely.
Okay. So we had the public hearing, many people came out, and some were opposed, and I don't recall totally, to certain things. Now, those things are being changed based on variances or whatever planning decided. And all I'm saying is that the public who came out ought to now know what will be voted upon, that's all.
And this is not a debate, and on the issue. Clearly, the town board has the right to put a resolution on.
Yes,
To vote it for another public hearing.
Right.
I don't think that it would, in terms of what happened, the public hearing is intended to offer the public an opportunity to hear what the application is and make their comments. They had opportunity before the town board, they had opportunity before the Board of Zoning Appeals. And my sense is, and if you read the memo which I attached to the one from Dave
I didn't
Flynn,
see it.
the building height was lowered from 35 feet.
No, I know all that, John,
But-
I know it all. You're
But
right.
that was what was, but the opportunity to be heard, both boards was provided to the public. And I think, and this is not for me to say, for me to handle, but if the board decides to do that and the board votes to do it, I wouldn't be surprised if we're in court right away with a restraining order, because they're going, I think the applicant would then say, well, gee whiz, we did this already, why am I going to all this extra additional expense and time to go for another hearing that the board wants us to do?
That's why, John, I'm saying, an informational hearing, I think, would be the better way, because of the fact, I don't even know how many of these conditions have changed and what's gone back and forth. Let the planning department and the applicant, if they want to, come in and just inform us how much better they made their application. I don't see anything wrong with that.
There's nothing-
From what I understand, it's gotten much, much, much better, but you're reading stuff here I had never even seen.
No, this
And
was
how does the
attached,
pl- how-
but this was attached to my memo to the board.
Okay, well, I didn't see that, I didn't see that
I
paragraph.
specifically-
The bottom line is, I think the people, at least let them be heard, and let the applicant be heard of how much better they made their application.
What's the harm done if you have the public hearing?
I
Or
see
the informational
information.
hearing?
Is,
Additional delay for the applicant, I think.
Well, it's not
All
out of
of which
secret
costs
yet, and
money.
it's not out of, it's not out of BZA, so, and it won't be by the date of this meeting, so I think if we let the people just hear how much better the application's got, it might lay their problems to rest.
Didn't they, John, though, didn't the public hear those conditions that David had sent over, where they were less intensive and made the project better, at the BZA public hearing?
it's my
That's-
understanding.
That's where they heard it, because
It's-
residents corresponded that they were now pleased with the project and that they met with the developer, and I believe that was at the BZA hearing.
It's my understanding that these changes were done that night at the Board of Zoning Appeals, where I think there was a give and take between the
Correct.
board and the applicant, and that's how they came up with those things. So I think that was taken care of at the public hearing. And I am not a proponent of having the public hearing or not. I'm not taking a position. That's the board's prerogative. I'm just telling you that for the sake of this application, I do not believe there's a distinction between a public hearing
But
and an
once
informational
again,
hearing.
Bob, what
But-
is the harm? Bob says a month delay. A month delay in the middle of winter. What's the problem?
It's not for me to answer.
Well, okay.
And that's, but I just, the board asked the
You
question.
see, you know what the problem is here? And it has to do with politics. People count heads. And they assume some people are for or against something. And that's the dilemma that occurs in this town board. I've never, ever said, me personally, whether I was for or against that project, ever to anyone. Let the process go forward. It went forward. Now there are major changes. Once again, what is the harm in the public knowing what the changes are?
Here's,
Well, you shouldn't have to answer the
but,
question.
but when you use the word major changes, I think, and that's why I wanted
To
to
the
just.
betterment.
But I'm, to the better, but I did the memo to the board on October 21st. And in the memo, I referenced Frank DeRubio's memo of October 1st and Dave's of October 8th. I do as a footnote all the changes. And I read them to you because the building height was lowered to 35 feet from 49. The top of the building was lowered to 99 feet from 112 feet above sea level. 2 6-foot-high retaining walls are proposed.
John,
But what I'm saying to you is, why?
That's a memo to the board. I know that. He knows it. We all know it. The public doesn't know it. And if you're saying that a BZA meeting suffices that people know what the changes are going to be, fine. I don't think so.
But again, Supervisor, that's the
But the
board,
board,
that's
listen,
the board decision.
The
That's not-
board, the board can vote to hear it or not hear it. I don't care. I don't know the relevance of Tommy's informational as opposed to public. If you're saying there is no
I don't
legal
believe there's
difference,
a
No, there's
distinction.
less weight of informational.
Who did you
Don't ha-
speak to? What's the
I
association?
don't have the
of towns?
gentleman's name, but you know the name, I got it written downstairs. And, it's just, all you're doing is basically, if the other side wants to just say, come to the podium and say, this is what we've done to make our application better, and that way, at least the people that are there can see it's made
But
better.
haven't all those issues been discussed before an open hearing of the BZA?
I haven't been at the BZA, Bob, so I don't know.
There are now additional changes that are being requested, if I'm not mistaken, Mr. Zolo, by the planning board.
Say it again, I'm sorry.
Planning board has now put in additional,
You mean the Board of Zoning Appeals?
no, has not,
Planning
Mr. DeRubius
Planning
asked
Department.
for new changes, new,
It's my,
conditions.
it's my understanding that, Planning Director Frank DeRubius, has suggested some conditions be imposed on the Board of Zoning Appeals.
after the
grant.
fact, after the BZA.
I think that they were done after the BZA hearing was closed, but I should suspect, and you have to have Mr. DeRubius here or a member from the Board of Zoning Appeals. I don't know, the conditions typically are put on or recommended by the planning director to the board as part of the planning advisory report.
but John, that, in my opinion, that's all the more reason to have information or a public hearing, because there are multiple changes the public doesn't know
But
about.
I feel like the board,
Well, I
all of
shouldn't
you
be
are asking
addressing
me,
you, it's really
that's
the
not
board.
my decision. As
Okay.
a legal matter, there is clearly no
And I-
public hearing required.
and
The
I
rest of
referenced
it's a policy decision
And
by
I
the board.
referenced that in my memo to the board.
Yeah, that's, and that's fine. So, I mean, so
I
I'm
don't
not.
even know why it's not out of the Board of Zoning Appeals yet. It just seems like it's just taking forever just to even get out of the Board of Zoning Appeals.
My understanding is,
I know it's secret, I know what the problem
but
is.
it's secret, my
And for
understanding.
when we're lead agency, which we shouldn't be lead agency for BZA, they should be lead agency
There's
for
a-
themselves. By a code change, the BZA
Right.
can have themselves as their own secret, and the town board don't have to be the lead agency for the BZA.
And I
They're an
s-
autonomous board. We should not be the lead agency for the BZA. They should stay 100% autonomous and not have to come under our purview.
Russ Barnett and I were speaking about that in, this case and the.
Because this not would have been
and Amber
not still
Court.
be in secret, it would have been done and probably settled to the BZA, so we would know what we even heard. We wouldn't even be talking about this. But the supervisor put this, and I said, I don't agree with a full-fledged public hearing, but at least we could have an informational hearing so we can know all the changes you know, all the changes Frank know, all the changes David know, and let the applicant say, hey, we've made this thing 100% better. We got 2 minor things, and we meet the full special exception criteria, and town board, you must approve us. And then at least we could have
And-
some more input.
And I just say, the law does not require that, but that's the
I'm not
board's
saying-
prerogative to do that if they want to.
I think it's gotten, if I understand, it's only down to 2 minor issues, and it meets the special exception criteria.
And, but anyhow, my understanding is November 26th, the Board of Zoning Appeals meets, and they're going to discuss the conditions that Frank has suggested go on the BZA application.
So that's another change.
And then-
That's another
No,
change.
it's the conditions that were in the October
Okay.
1st memo. And then, once the board kind of gets a sense of where they're headed, Russ will be able to complete secret.
No, he can't complete secret, really.
Yes.
No, he can't. The secret has to come to us.
Well, no, through
For
secret
us.
review.
Yeah.
And then on December 17th, what the board could do if they're so inclined is to put the secret on and then a resolution either with respect to a special exception permit and then vote it on December 17th.
We can't vote the special exception permit. It's gotta go back to the BZA first,
Mhm.
because they can't approve it until they get our secret. We're lead agency.
You do you just, as you did in Amber Court, the town board approves secret, and whatever decision the town board makes is subject to the grant of the variances. But the secret process could be complete after the board meets on November 26th, for us to put a secret to the town board to vote on December 17th. And that's how it was done in Amber Court.
Yeah, we did, that was the timeline on Amber Court.
Amber
So we-
Court was, the town
But
board.
but I haven't got an answer from anyone here other than Mr. Creighton, who said it delays it 1 month. What's the harm done in hearing it?
It's not the period of time that I'm concerned with.
Okay.
I think we do a disservice to all of the applicants that come by, continuously delaying projects over and over, because it costs them money.
How is there a delay if I have this hearing? Where's the delay? Where's the delay?
We won't hear it till January, end of January.
Right, okay, and I was told here that the BZA doesn't meet until December, what have you. What's the problem? We should be open, transparent government. That's what I wrote in my memo. That's what it should be. And what's the difficulty? That these guys are so anxious to build? Nobody's stopping them from building. I suspect the thing will pass. What's everybody concerned about? Too much counting of heads, too much inferences of who's going to vote and not vote. And I think that's BS. And I can't spell it out. Sorry.
I repeat,
Well,
that's
look,
the board's
the
prerogative.
board could vote no on the hearing, and it's the end of the tune, so that's the end of the tune.
Like I said, if the hearing is a good thing, for, not a public hearing, just an informational to the public and let both sides just say what they've done better and how they feel, I don't see the harm of that. We did informational hearings when we did the Armory project. People came up, they told what they liked, what they didn't like, and we put that all into consideration, that's how we ended up building it. You know, I don't understand why we can't just let both sides speak. From what I understand, it's a special exception. We must approve it or we're breaking the law. As per hearing last year that happened up in Albany, that they showed, special exception, you must approve it if it meets all criteria. It's that much for meeting all the criteria. I just like to see both sides and all the information, because for some reason, you get a memo, Bob, I get a memo, he gets a memo, but there's other memos that you don't get, he don't get, I don't get.
That's the case here. We
Yeah.
didn't get the memo.
I know, so I just think an informational hearing where everything's thrown at us, or bring it to a work session or something where we hear everything from both sides, what's going on, because I don't even know how to vote right now, because I don't know if it meets the special exception criteria, because no one's told me whether it does or not.
You have, but you do have a planning advisory report with respect,
That says it doesn't.
subject to getting variances.
That's what I'm saying. I mean, I think we should be informed. That's all. I mean, do it. I just don't
But-
think a full public hearing is the way to go.
What is the delay of 1 month due to the project, other than philosophically you said we're holding things up?
Well, it puts it off. It's not a month. Put it off for more than a month. It'll be put off until next year sometime.
Well, it is, it's January 23rd, it's a month, in December we have no meetings. January 23rd, I think I wrote in the memo, would be the informational hearing or whatever you want to determine. And then, if all things are in place, the board could vote it immediately thereafter.
And who would present at the hearing?
Anybody that wanted to.
Would you have the applicant come in?
Yeah, we would have, and he wouldn't have to do all that business. It would seem to me that with the traffic studies and all that, what was heard, is that correct? On the
hearings-
the
and the
public
hearing's
hearing for the
closed.
town board.
Public hearing's
And
closed.
whatever comments were made about the height, and they're not gonna see it from their home or whatever, all that has now been revamped, and it's changed dramatically. And I think all I did was very simply say, let the people know, because they had all these concerns, what is going to be built. Now you take the,
But Pat, at the BZA hearing, that was discussed in great detail
They all heard it.
by the people. They were there. They discussed the height of the building. They discussed everything in
well,
front of the
did they
BZA.
discuss the sewage treatment plant, or what how they're gonna treat the
They
sewage?
did.
Yeah,
They did?
all
Okay.
of that was done at the BZA.
But, okay, so you're saying, in effect, I think you're saying that the BZA hearing, so be it that some people went to it and some people didn't. I mean, a public hearing before a town board is quite a different thing than a BZA hearing. A town board hears the entire project, right?
Well,
And the BZA hears certain aspects of the project that they want to change or will change, or they're
what's the
told
subject
to
of the
change.
variance or whatever relief they're
Yes,
seeking?
exactly.
I just,
Look, the board would vote it yes or no, and I don't really care after this.
And I think the board had said one time, before we vote yes or no, even on the secret, we want to see, we want a sense of what the BZA is going to do, that it meets the special exception criteria, and we still haven't gotten that.
the board, again, you can speak to Paul Hennings if you want,
No,
but, you know, the Board of Zone Appeals is an autonomous body. They don't give you a sense of what they're going to do. And if you just take a look at the history of the timeline on Amber Court, the town board approved a special exception permit after secret was completed, subject to the granting of the variances. And Tommy, you're right, the special exception permit, if you meet the criteria, the town board is duty-bound
Yeah.
to grant the special exception. In this case, there are variances. And also, you have the general criteria that are set forth in the criteria for a special exception permit. So the board does have some latitude is looking at this and saying, well, we don't think you meet general criteria of 3 or 4. But more important are the variances that go to the Board of Zoning Appeals, but this board has historically granted special exception permits subject to the variances once secret is completed. I just point out to the board that while you have the absolute right to put this for another hearing, you could be, and again, that's what the courts are for. The only way that this would be thwarted is if the applicant goes to court objecting to the town board schedule for another public hearing. Whether they do that or not, I don't know if they would, but I want to bring it to your attention that that's the only.
Well, I think that's a terrible thing, John, that government gets thwarted because somebody says they may sue.
I'm just saying, I bring it to your attention.
The board can vote yes or no on it. I'm for having the hearing. Mr. McCarthy is for the hearing. If the three of you don't want to do it, don't do it.
I'm for an informational hearing. It's a different weight than a full public hearing. A full public hearing starts the secret clock all over again. It starts a lot of stuff that isn't necessary. I think an informational hearing to let everybody be heard, pro and con. I don't think you're going to get too many people out that are against it any longer. My understanding is that they've made this application in 95% of the special exception criteria, and they're on their way to finishing their last 2.5 items.
I'm just going to say this to the board. You have the absolute right, if you so decide, to vote this for a public hearing. On these type of applications, there is no such thing as an informational hearing. Informational hearing will be something like used as the Armory, where the town board is listing information on a project that it's in control of. This board and the Board of Zoning Appeals have already had the public hearings as required by law. So I don't want you to put this in a category of informational hearing because it does not apply to these type of applications. It's a public hearing just for your edification. However you want to go forward is your choice, but it's not an informational hearing, it's a public hearing that should be
We're
happening.
gathering information and informing the public. It's information to the public and information to us. That's not part of reopening the public hearing record. It's just
But you can't do that because
Yes, you
the
can do
record's
that, John.
closed.
You're wrong.
No, the record is closed, you can't.
I just said that, John. It doesn't go to the record. It just goes to basically give the public and the town board information that the project's getting better. And everybody needs to know where the project's gotten. The project's 95% there. It's waiting for the BZA, but what's hurting and letting everybody know that it's gotten better, that their fears have been relieved, so we can move forward with it. That's only, but check your town code, there's a difference.
It's on for this afternoon, correct?
It's on
Mr.
the
Vecchio
agenda.
says that's,
It's on the agenda. We voted, one way or the other.
Voted.
Well, does anybody feel difference regarding informational or public, or no one feels, I don't know where?
no, I don't.
Allow me just to bear that out, John. And I think you may be,
I'm just
I
trying to
wouldn't
make it
say because I
easier.
don't pretend to know the law. I think you may be right that it's an informational hearing has no weight in terms of what was heard before.
Exactly.
But if we had an
We don't want weight.
informational hearing and said, members of the board said to the public, these are the changes, so the planning director, the height of the building has been lowered, the sewage treatment has been changed to another system, buffer zones have been increased or decreased, depending whatever. And isn't that a nice thing to do? In my mind, it is. I mean, if I were a resident who was opposed to this, I'd want to know ultimately what the building would look like and how it's going to affect me. And if it's allayed my fears that I had at the public hearing, then it's wonderful. But anyway, so how you slice it, Mr. McCarthy, the resolution is faulty on its own face, if you're saying that, John. Is that right? Public hearing.
Here's the resolution. the way you phrased the question, I'd have to say this is faulty on its face.
Faulty on its face, okay.
But Supervisor, doesn't mean you can't have a hearing if that's what you want to do, but there is no legal requirement.
No, that I know.
No, and
So if that resolution read an informational hearing to be held regarding this project on the 23rd,
can you give me a chance to just take a look and do some research before it was, because
okay.
I wasn't expecting this discussion this morning.
This one's been beat to death.
Okay.
Okay. One of the things I was away, as you well know, resolutions come on my desk for personnel transfers without adequate background, without adequate backup, and I don't know how that happens. If it came out of a labor management meeting, labor management is not to deal with employees who are not doing the job or are miscreants at their job. Transferring people because the department head can't deal with it is not the right thing to do. And we've got a history of transferring employees who don't perform in one area and transfer to another area, and they only become a problem in the new area. Whoever those employees are, they need to be sanctioned, counseled, and dealt with the CSEA.
But the problem is, Mr. Wareheim has said it so graciously all the time, majority, unfortunately, of our department heads do not know how to counsel, write up, discipline, and do the CSEA rules and regulations properly. So then when you get to a problem child, all of a sudden, who's ever the weaker department head gets it jammed down their throat. And if they would do the work of writing, counseling, calling the CSEA rep in, and after, I think it's 3 times, 4 times it is, Eddie, you're the expert in this because you ran the Parks Department for 20 years. The bottom line is that employee would be fired, not transferred and made a monkey on somebody else's back. And that's what happens here. All we keep doing is moving bad people around or problem childs around and make it another problem with someone's child because the guy says, okay, whatever you guys need, I'll help you out. And it's really not right to either or. We need to you need to do a disciplinary action because then you see your good employees see, oh, that particular person got moved. And Eddie, you've said this graciously many times. That particular person gets moved. Oh, I guess maybe I don't have to do my job now. Maybe I'll get moved to a department I want to get out of here too.
My information on this particular matter was that this was vetted through labor management, the town personnel director. There were interviews of employees, and this was a decision made by the union, labor management, town personnel, and that was their recommendation. That's how it got to me.
Well, I want
And
to
then I
tell
see a
you,
letter from the department head in this particular matter and says it's totally going to screw up his department if this change happens. So how do you do this to this department?
I don't have it here, but I did requisition the mission statement of the Labor Management Committee. It is not to deal with personnel problems like the one we're describing. It has to do with grievances and management and contract, not individual employees' behavior.
Like I said, Eddie said it. Eddie, John Valentine, we know the department heads that do the system right because those people have been on the agenda and they've been let go. The bottom line is we need to do another full department head set and for everybody and say, listen, this is how it works, and let the CSEA come in and explain to them how you got to counsel, how you have to have the union rep there, how people have to sign up, how they have to initial the. I mean, I got the one file from the department we're talking about. The person was talked to, but it was never signed by the employee. It was never signed by the department head. They didn't waive their right to CSEA members or their union rep. Nothing. It's just a blank piece of paper stating what happened. It has no weight. So again, you're going to move a particular person somewhere and ruin another person's department who says it's going to be detrimental to the move. So I don't know how you do it.
No, because we don't want it, personally, we'd have to go in executive session, okay? We're just talking generalities. Okay, fine, you can speak generalities.
Generality becomes, he's a
You gotta be
department head.
careful here.
There's a folder full of information on
Yeah,
a particular
yeah.
person
Right, right,
and testimony.
right.
But the folder that's on a particular person has absolutely not one signature from a department head, has no signature from a union rep, has nothing. It's a blank form that and it's great to fill it out, But if the person was counseled, and Eddie, you knows what better than I do.
Mr. Supervisor, I'm under the impression that those personnel matters are strictly between myself and personnel and
Well,
the
I mean,
union.
Vinnie, maybe we ought to get into
should
executive
probably
session.
executive session, Supervisor,
Absolutely.
Bottom line, Eddie, would you have done, for that particular department, would you have done sheets like that?
I don't.
Well, you see the one sheet, there's no signatures, there's no nothing, it's just basically what the problem was. Okay, the problem is, okay, Eddie, you were a bad boy today. That's it. Okay, it's written down.
Supervisor, there can't be more than one sheet in there. There's got to be
No,
at least,
there's 5 sheets here. I just,
there's several sheets in
yeah,
there.
I might suggest you take this into executive session. I think that would be the more appropriate way to handle this, Mr. Supervisor.
Well, it's in general, basically, because the department heads all need to know, and that part doesn't have to go into executive session. And Mr. Wilhelm has said it a dozen times, maybe 24 times, on how it's supposed to be done. Mr. Valentine has said how it's supposed to be done. Unfortunately, it doesn't do it, so we just keep moving problems onto one person or the other, because
Yeah.
that department says, I'll do it, guys, for you. And it's just not the right way. You just can't keep moving things back and forth all over the place. You need to do the system right. You need to be a boss of your department, whoever the particular department is.
okay. I have another personnel matter, which you asked, send a memo. Did the town board ever resolve this matter? So that's a personnel question,
Correct.
right?
Can I address something, Mr. Vecchio?
Please.
This is a little less controversial. It's just a suggestion that we take a look at something. I was given a petition by about 605 people for the town board to consider the purchase of property at the rear of the corner of Pulaski Road and Main Street
Yeah.
in Kings Park, where the bakery is.
Yes, I know it.
And
I know.
there's a parcel of land back there that's for sale. The petition is for us to explore that possibility for the purpose of making that a
Parking lot.
municipal parking
Yeah.
lot. The property, as I say, is for sale. I have the owners of the property, and I would suggest that we explore that possibility.
Yeah, I think that's a good suggestion too, but I've thought about that. The complaint is that most of the parking that's available is made up by employees and people who stay there a long time. And if we were to consider that, and I think it's a good idea, then you have to have some means of restricting parking for an hour so that people can come and go. There are more facets. Our concept of adding parking is a great idea, and I'd be amenable to that, but I think we'd have to figure out.
Well, in fairness, part of this problem has come up during the construction which has taken place there.
Yes.
And there has been no parking on Pulaski Road. There is now parking on Pulaski Road, but it is very limited. It's only
Well, that's a good idea.
2 or 3
You
spots.
Yeah, I'm
restrict it
not
to 1
disagreeing
hour,
with that.
2 hours, something
But
like
you'd
that.
have
But
to
there
figure out
there
how
are
to-
restrictions there, but
Okay, so
If the town were to explore that, and I think
We're talking about a new park.
because I had asked David Flynn about that, it's about 21 spaces they will get out of it.
Well, that way.
And the
it's-
question then will be,
Yeah,
how do you
days, 8
allocate
hours.
those
The whole
spaces
thing isn't just- we're not just
to make
looking
sure that
for
there's a
parking.
turnover, so everybody has an opportunity? I'm
so,
open to that.
I think it's
so
worth-
we ought to at least take a look
We
and
ta-
see.
Absolutely.
How
I
big is
agree.
the lot, Bob?
I can't tell you exactly, but Pat says it's about, how many spaces, Pat?
21,
21
22 at most.
spaces. It's not a big, it's not a
No, it
big
sounds like
cost.
it'd be good, like, but the restriction makes
And
sense.
it would service that entire shopping center, and in
Yes.
fact, the stores on the opposite side of the
But
street.
The
once
biggest
again-
reason stores fail is you can't find a parking space, they go somewhere else, and it's a good idea.
Well, it's true.
That's something that we could do. It is possible to restrict, right? We do. Because I agree, you would have to do that so that you don't have people parking there all day and leaving their vehicles.
We most definitely.
So it's worth
do
looking
it
at.
And can do it.
Yeah, that would have to be, okay. This also is a personnel matter. We got a memo here regarding that's not personnel, flexible spending account plan changes. Does the board want to allow employees to do that?
Yeah.
They can set aside $500 pre-tax,
Right.
It's fine.
That's fine.
fine, okay.
Well, actually, the 500 carries over to the following calendar year.
Right.
And-
So who's a personnel person here?
There we go.
Actually,
Oh,
I don't
no.
even think it needs a resolution. I think it's basically, if I recall, I think it's changing the law that allows them to carry over a percentage of it in the IRS regulations.
Yeah, it does.
Yeah.
Okay, so I'll move to go to executive session, do the personnel matters first, and then the contractual matter after that. Okay?
Yep.
I move to go into executive session.
Second.
Aye.
Aye.
John? You guys don't want to bring Vinnie up?
For what? What are we gonna accomplish?
You're on. All right, you're on, Pat.
I move to close the work session.
Second.
All in favor?
Aye.
Aye.